Good morning. Good morning to all of you. Is it audible to all of you? Write down the next topic, that is key terms in polity. So, articles, parts, and schedules. Okay, can anyone tell me what is an article? So, what is an article? What is your understanding? In singular, it is article. If you put it in plural, it is articles. What is an article? A specific provision in the constitution. Very good. So, basically, what did we understand as to what is a constitution? Can anyone recollect the definition of constitution? The fundamental rule book of the country. That means we can say the constitution is a collection of rules. There are a lot of rules inside the constitution. But basically, what is there in the constitution? The constitution contains a number of articles. So, collection of those articles or collection of those rules makes what is called as a constitution. So, what is an article? An article is a specific rule in the constitution. So, the collection of all these rules makes up what is called as a constitution of India. So, please write down what is an article. An article is a specific rule in the constitution. An article is a specific rule in the constitution. For example, Article 1 says, what is Article 1 says? Article 1 gives us information with regard to what is the name of our country, what is the kind of political union of our country. So, similarly, each and every article talks about specific provisions. All right. So, an article is always what is called as a specific rule in the constitution, be it Article 1 or be it Article 395, it does not matter. Each and every article is what? Each and every article is a specific rule in the constitution, and the collection of these rules makes up what is called as a constitution of India. Is it clear to all of you? So, whenever I use the word article, article is a specific rule in the constitution. All right. So, only that the rule may vary depending upon the article numbers. Now, already we have seen how many articles are there in the constitution. 471 articles, but it is not that the article number is 471. Do you know what is the last number of the article? It is 395. There are only 395 in terms of numbers, but however, if you see there are 471 articles, how is it possible? It's possible because some of the articles are seeded as A, B, C series. So, for example, it will be Article 371A, 371B, 371C, 371D, but they are independent articles in itself. Say, for example, Article 31A, Article 31B, Article 31C. So, in this way, if you see, there are certain articles which A, B, C are there. Not every articles are like that, but each and every article is a independent article, which means there are specific rule in the constitution. So, what is an article? Article is a specific rule. Now, what is a part or a parts? So, how many parts are there in the constitution? How many parts are there presently? 25 parts. In the original constitution, there were 22 parts. So, presently there are 25 parts. So, basically, what is a part? Part is a collection of rules. I would say that the constitution is also a collection of rules, but part is a subcategory of that. I would say part is a collection of rules or collection of articles, but related to a common theme. Related to a common theme. So, what is a part? Part is a collection of articles or collection of rules related to a specific or a related to a common theme. Say, for example, Part 3 of the Constitution. What is a Part 3 of the Constitution? Dealing with fundamental rights. But if you see Part 3 of the Constitution, it is containing from Article 12 to Article 35. But all these articles are dealing with a specific theme or dealing with a common theme. What is a common theme for all these articles? They all deal with fundamental rights. Is it clear to all of you? So, part is a categorization of various rules, grouping of various rules dealing with what is called as a common theme. Is it clear to all of you? So, you should know what is an article, what is a part. And then the last thing is schedule or schedules. What is schedule? So, schedule is basically like a table or it is like an appendix. If you see any books, there will be tables and appendix. Now, for what reason these tables are used? For what reason these appendix are given in the textbook is to properly organize certain information. Otherwise, it looks so clumsy if you put it in the middle of a particular text. So to organize it very effectively, you are placing that information in the end. So in similarly, if you see, these articles are flowing from certain articles, sorry, these schedules are flowing from certain articles only. So for example, how many schedules are there in the Constitution of India presently? 12 schedules. We know that original constitution had 8 schedules. So presently, how many schedules? Presently, there are 12 schedules. And say, for example, Schedule 1 of the Constitution. Do you know the Schedule 1 of the Constitution flows from which article in the Constitution? Does anyone know what is Schedule 1? If you're not aware of it, do not see it to be a negative thing, but you will just learn it. But somebody knows the answer. So the Schedule 1 of the Constitution deals with what? Territory of India. Very good. Not only just the territory of India, it deals with the names of the states, names of the union territories, and also their corresponding territories. So Schedule 1 deals with all these things. But my question is, do you know which article? Because the schedules are not separate. They're all part of articles only. They're all part of some articles. But there are schedules are something which an article may not ordinarily contain all these informations, but they're separately giving this information in the schedules. So can anyone tell me what is the source of Schedule 1 in the Constitution? Very good. Article 1 of the Constitution is the source of Schedule 1 of the Constitution. So, Article 1 of the Constitution is the one which gives the names of the various states, the names of various union territories, and the territory of India. But instead of giving that in the words of article, text of Article 1 itself, they are saying go and look to the Schedule 1 of the Constitution. So, basically, what is a schedule? Schedule is like a table or an appendix, which does provide additional information which otherwise is not given in the article respective rule. That is basically what is called as a schedule. Just write down a line. Schedule is like a appendix. Schedule is like an appendix or table that provides detailed information about a subject matter dealt by a specific rule or an article. Dealt by a specific rule or an article. Dealt by a specific rule or an article. So therefore, the schedule itself comes from where? Schedule itself comes from the respective article in the Constitution. Is it clear to all of you? Therefore, not every article may provide for a schedule. Wherever there is need for additional information, that article will provide for what is called as a schedule. That means overall, how many articles are providing for schedules? Though we have 471 articles, we have only 12 schedules. It just said only 12 articles are providing for little bit detailed information in the form of what is called as the schedules. So is that clear to all of you? What is an article? Article is a specific rule. Part is a collection of rules, but they are related to one another. So for example, part 3 fundamental rights, part 2 citizenship, part 1 union and its territory. So in that way, the related articles are grouped in a particular part. So in that way, overall, these 471 articles in the Constitution are grouped into how many parts today? They are grouped into 25 parts. And of course, we have what is called as 12 schedules in the Constitution. So that's basically what is called as an article, part, and a schedule. Is it clear to all of you? In singular, it is article, part, and schedule. And in plural, it is articles, parts, and schedules. Is it clear to all of you? Okay, so write down the next keyword, judicial review. Judicial review. Okay, so sir, do we need to learn all the articles, parts, and schedules? So what do you think? Is it necessary for you to remember each and every single article in the Constitution? Not at all necessary. Even the members of UPSC or most of the IAS officers in our country or those who are already in various capacities, they also do not know all the articles. And UPSC do not expect you to know all the article number, but UPSC may expect you to know the major structure of the Constitution. That is the provisions. You shall not remember each an article number, but you shall know, okay, these provisions are there in the Constitution, even if you're not knowing what is called as exact article number. But having said that, you just believe me, during the entire process, at least 60 to 70 articles will automatically get into your mind. And remaining provision will also be there in your mind if you follow the classes properly. But there are certain articles, like articles related to fundamental rights, articles related to constitutional bodies, article which are so important in certain cases, say like money bill and all those things. So it will automatically get into your mind over a period of time. But there's no need that absolutely you should remember all the articles. Is it clear to all of you? That is not the requirement. At the maximum, there may be one question which may come purely from article or one statement from article, but that is all exception, and that also most likely will be falling under the 62 or 70 to 80 articles that you may remember over a period of time. No need. Parts you don't have to remember. Parts you don't have to remember, but that's not a very difficult thing. There are few major parts like Part 3, fundamental right, Part 1, union and its territory, Part 2, what is citizenship, Part 4, what is called as union executive. So in this way, as you'll proceed, you'll remember automatically most of these things. All right. And schedules, anyways, you'll have to remember because they can explicitly ask one question from the schedule. I'm not telling that you should remember each and every word content in the schedule, but you should know at least schedule 1 deals with what, schedule 2 deals with what. Very simple questions are likely to be asked from this particular area. So this is how we'll proceed with these things. All right. So come to the next topic, that is judicial review. Write down. Align. Judicial review basically means the power of the judiciary. Judicial review basically means the power of the judiciary to review the actions of the legislature and the executive, to review the actions of the legislature and the executive, and to declare such actions to be unconstitutional, and to declare such actions as unconstitutional if they are in violation of the constitution. If they are in violation of the constitution. So basically, what do you mean by judicial review? So judicial review is the power of the courts to review the actions of the other two organs of the state. And it doesn't mean that the judiciary can strike down all the actions of the other two organs of the state. When they can strike down the actions of the other organs of the state? Only if it is in violation of the constitution. Is it clear to all of you? So write down just one example. For example, Article 13. So how many of you heard about Article 13? Does you know what is Article 13 is all about? Definition of? No, Article 13 does not deal with definition of state. Okay, so what is Article 13? Article 13 is talking about that no law in our country shall be in violation of the fundamental rights. Anyways, we'll deal with Article 13. But basically, what is Article 13? How it is related to the concept of judicial review? I'm not dealing with Article 13 in itself. I'm just trying to relate that to the power of what is called as judicial review. Now, what is the power of judicial review? It is the power of the judiciary to look into the actions of other two organs of the state. If their actions are in violation of the constitution, what can be done by the judiciary? The judiciary can declare that action to be unconstitutional. That is, it is not legally valid. It is null and void. Null and void means not legally valid. So, under Article 13, the judiciary has a power of judicial review. So, the power of judicial review is implied under Article 13 of the Constitution, because what is the crux of Article 13 is saying? Article 13 is saying if any law is in violation of the fundamental right, that law can be declared to be void by the courts. So therefore, Article 13 in crux is saying that no law in our country can be violation of the fundamental right. That means, where is fundamental right in the Constitution? It is there in Part 3 of the Constitution. It is given in the Constitution itself. And just now we have seen what are the articles that deals with fundamental rights. Article 12 to Article 35. They all deal with the fundamental rights. In that, Article 13 is saying, if any law is in violation of the fundamental rights, who has a power to strike down that particular law which is in violation of fundamental rights? The courts have the power to strike down those laws. So when I say when any law is in violation of the fundamental rights, that means any law made by the parliament, any law made by the state legislature. Can they be in violation of fundamental rights? No, they cannot be in violation of the fundamental rights. If they are in violation of fundamental rights, who has the power to strike it down? Judiciary. So therefore, what is the power that the judiciary exercise under Article 13? They exercise a power of what is called as judicial review. Now, similarly, this power is also given to the judiciary under Article 32. So these are all examples as to how the judiciary exercise the power of what is called as judicial review under the Constitution. Does Article 32 gives, does any know what is this Article 32? If you know, it's okay. Otherwise, we'll read all these articles. We'll go all these articles one by one. But if you know, anyone? Yes, Article 32 gives the power to the Supreme Court to issue writs for the protection of fundamental rights. That means, to put it in a very layman words, whenever the fundamental rights are violated, under which article the affected individuals can approach the Supreme Court? Under Article 32 of the Constitution. Therefore, does it give the power of the judiciary to look whether an action by the executive is violating the fundamental right? So, for example, if the police arrest an individual arbitrarily, let us assume, can the police arrest any citizen in the country as per their whims and fancies? Suppose if the government does not like a particular individual, the government think that this individual is continuously criticizing me, that is the government. So can the government use its state machinery like police to arrest that individual arbitrarily? If the individual is arrested arbitrarily, let us assume, what fundamental right of him is violated? Right to freedom of speech? No, freedom of speech can be related, but that's not a major right that is violating in this case. Which right is the major right? When somebody is arbitrarily detained, arbitrarily arrested. What is that? Very good. What is that? Right to life and personal liberty. Your liberty is restricted. Suppose if you are outside in your home, you can do a number of action. But if you are arrested, what is restricted? Your personal liberty is restricted. Can you say that I want this food, I wanted to cook, I want to watch TV, I want to go and meet my friends when you are in detention? That is not possible. So personal liberty is variety of actions that you can do in your life. So what is majorly getting restricted? Your right to life and liberty is getting restricted when it is arbitrarily detained. It is not that if you do a mistake and then the police arrest you, you cannot claim that your right is violated, because most of the fundamental rights are not absolute in nature. It can be restricted. But when there's an arbitrary detention, of course, your right to life and liberty is restricted. Suppose, even for some mistake, they are arresting you. Do you know that still the Constitution says that you'll have to be produced before the nearest magistrate within a period of 24 hours? If they don't produce you before the nearest magistrate within a period of 24 hours, then also your right under Article 22 is violated. So in this way, now try to understand, suppose if any of the fundamental right is violated, an individual feels that the police has arbitrarily arrested and his fundamental right is violated, can they move to the Supreme Court under Article 32? Yes, they can move to the Supreme Court. So therefore, the Supreme Court is trying to review what? The actions of the police. So therefore, this also gives a power of what? To the judiciary. It also gives a power of judicial review. So these are all examples of how the power of judicial review is given to the judiciary. Is it clear to all of you? But anyways, the idea is not to explain you completely what is Article 13, what is Article 32. That is not the idea. The idea is just to make you understand what is the concept of judicial review. So what is the concept of judicial review? It is a power of the courts to review the actions of the other two organs of the state, that is legislature as well as executive. And if any of their actions are violative of what is given in the Constitution, then what the judiciary can do? The judiciary can declare their action to be null and void. Is it clear to all of you? This is what is the concept of judicial review. Come to the next thing, that is amendment. Yes. That's why I'm not, the idea is not to explain you Article 13 and Article 32 because you'll not understand that right now. So therefore, if I'm not saying something, it is for a purpose, because you'll have to go and understand what is Article 13, what is law, and all those things. Then only you'll understand that. So implicitly, you understand that the idea right now is only to express what is judicial review. I clearly told that idea is not to explain you Article 13 and Article 32. That's a little bit ahead. It will take another 4 or 5 classes to go to that particular area. If I say right now, probably someone who has got an idea might understand, but my idea is to take everybody together. I cannot give a pointed attention only to a particular individual to their level of knowledge. I'm not sure whether you may also understand or not, but even if you have a capacity to understand, I cannot entertain that at this moment because everybody has to be taken together. All right. Yes. Write down the next thing, that is amendment. What does basically the word amendment means? Amendment basically means here specifically in the constitution, when we deal with polity, whenever you use the word amendment means amendments basically refers to what is called as changes to the constitution or changes to the ordinary law also. But most importantly, it is making changes or alteration to the constitution of India. So write down amendment basically means alteration or modification to the constitution of India. Alterations or modification to the constitution of India. So does anyone know who has got the authority to make amendment to the constitution of India? Okay, so please write down. Parliament is the only authority. Somebody told state legislature. The state legislature has no authority to do that. So Parliament is the only authority to make amendment to the constitution of India. Parliament is the only authority to make amendment to the constitution of India. And does anyone know which article or which rule in the constitution gives this power explicitly to the parliament? Very good. It is Article 368 in the constitution. So Article 368 in the constitution gives this power only to the parliament. Okay, so one more factual question let me ask. Does anyone know, using this power under Article 368, how many times do you think that the parliament has amended the constitution till this time? What is the latest amendment? What is the number? I was asking only the number. 100 and? Okay, 107, 106, any other number? 103, he told 103. 113. 32. 32 will likely to happen, maybe probably we'll have to wait for another 20-30 years. I don't see, because an amendment happening to the constitution is not an easy thing. So yes, the right answer is 106 Constitutional Amendment Act. So far, it is 106 Constitutional Amendment Act. So don't get confused with an amendment bill. Amendment bill is not an amendment. Whatever is approved by the parliament is only what is an amendment. So anyways, the latest amendment that has happened to the constitution is the 106th Constitutional Amendment Act. Is it clear to all of you? So 106 times the constitution has been amended under Article 368 of the constitution. So that's the correct number. Right on the next thing, that is rights. Rights already we have learned. So just a line you can write it. Rights are nothing but claims and entitlements of the individuals. Rights are claims and entitlement of the individuals. Rights are claims and entitlements of the individuals, which can be enforced in a court of law. Which can be enforced in a court of law. Which can be enforced in a court of law if they are violated. Which can be enforced in a court of law if they are violated. Which can be enforced in a court of law if they are violated. Depending upon the source of the rights. Depending upon the source of the rights, they can be classified into 1. Fundamental rights. Depending upon the source of the rights, they can be classified into fundamental rights. 2. Constitutional rights. 3. Legal or statutory rights. So last class itself we have covered this. So depending upon the source of the rights, they can be classified into 1. Fundamental rights. 2. Constitutional rights. 3. Legal or statutory rights. What is a fundamental right? Whatever is there only in the part 3 of the constitution. What is a constitutional right? In the constitution, but excluding part 3. What is a legal or a statutory right? Which is flowing from the ordinary laws of the land. So that is a statutory or legal right. For all the things we have seen examples also. Okay. So write down the next thing, that is writs. Writs. Writs are nothing but please write down writs. Writs are nothing but directives issued by the courts especially to protect the fundamental rights. Writs are nothing but directives issued by the courts, especially to protect what? Especially to protect the fundamental rights of the people. Especially to protect the fundamental rights of the people. Write down one more line. The Constitution empowers both the Supreme Court. The Constitution empowers both the Supreme Court under Article 32. The Constitution empowers both the Supreme Court under Article 32 and the High Courts under Article 226 and the High Courts under Article 226 to issue writs to protect the fundamental rights. To protect the fundamental rights. So you should have to remember these articles. Under which article the Supreme Court can issue writs to protect the fundamental rights? Under Article 32. Under which article the High Court can issue writs for protect? Under Article 226. Now both the Supreme Court and High Court can issue 5 types of writs. So I'm not going to explain you the writs. I'll do that later. But at least you should know the names of these writs. Now both the Supreme Court and High Court can issue under the respective articles. The Supreme Court can do it under Article 32 and the High Courts can do it under Article 226. So what are the writs that they can issue? So 5 types of writs. You can make a note of these things. One is writ of habeas corpus. So one is a writ of habeas corpus. 2, they can issue a writ of mandamus. 3, they can issue a writ of prohibition. 4, they can issue a writ of what is called as certiorari, CERTIORARI. Certiorari. And 5, they can issue a writ of quo warranto. Habeas corpus, HABEAS, habeas, CORPUS, mandamus, MANDAMUS, prohibition, PROHIBITION, certiorari, CERTIORARI, and then quo warranto, QUOWARRANTO. So these are the 5 types of writs. So we'll deal with all those writs, but for timing, you understand that depending upon the nature of violation, for different violation, so because there are many fundamental rights, depending upon the cases, depending upon the nature of the violation of fundamental rights, different types of writs can be issued. So basically the idea is, what is a writ? A writ is basically a direction which is issued by the courts. So whenever the court issues a writ, it can be any one of these writs, especially when it comes to protecting what is called as a fundamental right. Alright, so whenever I use a word writ, what has to come in your mind? Writ is basically what? Writ is basically a directive or some official order that is passed by what is called as a courts, to especially to protect what? Protect the fundamental rights. Why I'm using the word especially? That the writ can be issued not only to protect the fundamental rights, it can be used for protecting the legal rights also. But the Supreme Court of India can issue writs only for protecting the fundamental rights. So Supreme Court has got the power to issue writs only for protecting which rights? only fundamental rights. But the High Court has got the power to issue writs not only to protect the fundamental rights but also to protect the legal rights. So that is the reason I'm using the word especially to protect what? Especially to protect what is called as the fundamental rights. Anyways, writ is basically a directive that is issued by the courts. Right, and the next thing, that is nominal executive. Nominal executive. Nominal executive. Nominal executive means, I don't. Nominal executive means executive for namesake. Executive for namesake, or in other words, the executive does not exercise, or in other words, the executive does not exercise and enjoy the real authority. The executive does not exercise and enjoy the real authority. For example, though the President of India is the head of the Union Executive, though the President of India is the head of the Union Executive, though the President of India is the head of the Union Executive, he or she is only a nominal executive. He or she is only a nominal executive under the Constitution of India. He or she is only a nominal executive under the Constitution of India. So what does this mean? So we always say that the President is the head of the Union Executive. Though the President is the head of the Union Executive, what is the actual position of the President under the Constitution? He or she is only a nominal executive. That means they do not exercise the real powers. So can anyone tell me who exercises the real powers then? The Prime Minister and his Council of Ministers. They exercise the real power. Therefore, the President is only a ceremonial head. The President is only a nominal head. But the real power lies with whom? The real power lies with the Prime Minister and the Council of Ministers. Okay, on the one hand, we are saying that the President is the head of the Union Executive, but the President does not exercise any real powers. Who exercises the real powers? The Prime Minister and the Council of Ministers. How do you say that the Prime Minister and the Council of Ministers only exercise the real power? What provision, if you have any idea, what provision is there in the Constitution which makes, despite it explicitly says that the President is the head of the Union Executive, but we also understand that the President is only a normal executive and the real power rests with whom? Prime Minister and the Council of Ministers, because of a specific provision in the Constitution. Yes, Article 74. But what does it say? Okay, so the simple concept is Article 74 mandates that the President shall act on the aid and advice of the Council of Ministers. Suppose, let us assume that someone is the owner of the company, let us assume, to put it in a very simple way, or someone is the director of the company, but the director can take any decision based on the advice which is given by another individual. So therefore, the real power is what? With whom? Someone who can give the advice. So similarly, here it is a Prime Minister and the Council of Ministers who has to advise the President. Without their advice, the President cannot do anything. Therefore, the position of the President under the Constitution of India is what? Only a nominal executive. The real decision-making authority lies with whom? The Prime Minister and the Council of Ministers. Is it clear to all of you? So whenever I say a nominal executive, that is also what is called as de jure executive. That is executive for namesake. Though the Constitution provides for it, the real powers does not exercise by the nominal executive. That is what you'll have to understand. Write down the next thing, that is electoral college. So these are all words that we keep repeatedly using as we'll proceed. So once in today's class I explain it. So in the future course, I'm not explaining you again what is an electoral college. I'll just use the word electoral college. You should be in a position to understand what does it mean. I'll just use the word, say for example, amendment. I'll not explain it. I will just use the word what is called as judicial review. So you should be in a position to understand what is judicial review. Write down the next thing, that is electoral college. Write down what is an electoral college. An electoral college is a specialized body of people. Electoral college is a specialized body of people who shall exercise, who shall exercise, who shall exercise the right to vote, who shall exercise the right to vote in certain elections, who shall exercise the right to vote in certain elections. It is to be noted, it is to be noted, it is to be noted, the concept of, it is to be noted, rather than the concept, just write out, it is to be noted the principle of, it is to be noted the principle of universal adult franchise does not apply, does not apply, does not apply whenever the election is based on, whenever the election is based on specific electoral college, whenever the election is based on specific electoral college. Okay, so please listen to me for a couple of minutes to understand this. So when we use the word electoral college in polity, so electoral college means it's a specialized body of people. And when I use the word electoral college, it contains a specialized body of people. Only the people who are part of the electoral college will have the right to vote in certain elections. The people who are outside the electoral college, they will not have the right to vote. So normally, when it comes to the election to the Lok Sabha and election to the Legislative Assembly, we follow the principle of what? We follow the principle of universal adult franchise. That means every eligible adult individual shall have the right to vote. But we do not follow the principle of universal adult franchise for all the elections in our country. Only for the major democratic elections, we follow the principle of universal adult franchise. But there are certain elections, we follow the principle of what is called as, or we follow the elections based on the electoral college. That means only specific members who are part of the electoral college will have the right to vote. Say, for example, there's a separate electoral college for the election of president. There's a separate electoral college for the election of vice president. So, has anyone in this particular class, have you ever voted to the election of the president? Have you voted to the election of the Legislative Assembly or the Lok Sabha elections? That is because you are based on, that is based on the principle of universal adult franchise. But the election of the president and the election of vice president, does anyone have an experience voting in the election of president or vice president? To vote in the election of the vice president, you should be a member of parliament. To vote in the election of the president of India, you should either be a member of parliament or a member of state legislature, state legislative assembly. So I'm sure that none of you here is an MLA or a MP. So at least for time being, that is not the case. So only when you become an MLA or an MP, you can vote in the election of the president. And only when you become an MP, you can vote in the election of the vice president. That means the election of the vice president and the president in our country is based on the system of what is called as electoral college. So there are different electoral college for different elections. So the idea is not to explain how many different electoral colleges there, but just to explain you what is called as an electoral college. Do you understand what is an electoral college? An electoral college means it will have a group of people, and only the people in that particular body will have the right to vote. So just to understand further, I don't. For example, the vice president of India. For example, the vice president of India is elected by an electoral college. For example, the vice president of India is elected by an electoral college comprising of. For example, the vice president of India is elected by an electoral college comprising of members of both the houses of the parliament. Comprising of the members of both the houses of the parliament. So comprising of the members of both the houses of the parliament. So can anyone tell me how many members are there in the parliament? How many members are there in the Lok Sabha? How many members are there in the Rajya Sabha? So in the Lok Sabha, how many members are there? Very good. 543 is a strength in case of Lok Sabha. How much in Rajya Sabha? How much in case of Rajya Sabha? Any idea? including both elected as well as the nominated members. How much? 260. The maximum strength itself is only 250. But there are not all the seats are filled. Okay, so therefore the maximum strength that is occupied today is 245. Okay, so only these many people will have the right to vote. So either they should be a member of Lok Sabha or they should be a member of Rajya Sabha. And when it comes to the election of the vice president, there is no distinction as to whether they are an elected member or nominated member. Everybody will have the right to vote. So they should be a member of parliament. Is it clear to all of you? So for all the 543 members in case of Lok Sabha and all the 245 members in case of Rajya Sabha, they will all have what is called as the right to vote. Only these people will have the right to vote because it's based on the system of what? The electoral college. Therefore, for the election of the vice president, who constitute the electoral college? The members of both houses of the parliament is the electoral college, because the constitution only gives them the right to vote, unlike the other elections. So there are different elections in our country. It is based on the principle of electoral college, and the electoral college itself may vary from election to election, because the electoral college of vice president is different, the electoral college of president is different. So the electoral college may vary, but I'm trying to define you what is an electoral college. An electoral college means a group of people, only they'll have the right to vote. Is it clear to all of you? That is what is electoral college. So write down the next thing. First past the post system. First past the post system. Yes, go ahead. Don't worry about that. Present and voting is all to calculate the majorities. Right now, you just see, I'm not saying how the voting has to happen or what is the majority. That is not our concern. Our idea is what? Our idea is just to understand that who has the right to vote. That is, only the members of the electoral college will have the right to vote. All right. Right to the next thing, that is the first past the post system. First past the post system. It is a system of election. It is a system of election. It is a system of election in which any candidate who has got the maximum number of votes, in which any candidate who has got the maximum number of votes, is declared to be the winner. In which any candidate who has got the maximum number of votes is declared to be the winner. This is basically what is called as a first past the post system. Suppose let us assume, please listen to me. Suppose let us assume 100-meter race is there. In a 100-meter race, usually who will be declared to be the winner? Anyone who crosses the post first, anyone who crosses the line first. So therefore, usually how many winner will be there in the 100-meter race? Most likely one. It is very rare chances that both of them cross at the same time. Even in that, there will be fraction of second. So anyways, there will be one winner, clearly. But suppose instead of this, let us assume that the rules is changed. They're keeping the rule. They're saying that anyone who crosses a post before 10 seconds, then how many winner will be there in 100-meter race? Yes? Multiple? In India, nobody has crossed the post before 10 seconds. Suppose if the competition happens in India, there can be no winner at all. There's a possibility. There cannot be multiple people. How can you say that many people can cross it before 10 seconds? Because I have not told. It depends upon who is participating in that particular running race. So there can be multiple winners also. There can be no winners also. Even the same person who has crossed before 10 seconds, not necessary he will always do it every time. So therefore, the possibility is there can be no winner also. There can be multiple winners also. But why they are saying that anyone who crosses first? The reason is definitely they will have a winner. And definitely there will be one winner. Now, similarly, there are a lot of elections in our country that is based on the principle of what is called as first past the post system. The first past the post system is the simplest way of conducting the election, because they know that some winner will be there out of the election. Now, where this first past the post system is followed, it is followed in the election to the Lok Sabha. It is followed in the election to the legislative assemblies as well. Suppose let us assume that there are 4 candidates who are contesting election, let us assume. So let us assume this is a legislative assembly election or Lok Sabha elections, whatever it is. 4 candidates who are contesting election in a constituency, and let us assume candidate A is getting 40% vote. Candidate B is getting 30% vote. Candidate C, let us assume, is getting 20% vote. And candidate D is getting 10% vote. That means there are 100 voters. How many voters are voting in the election? 100 voters are voting in the election. And accordingly, these are the percentage of votes that is got by A, B, C, and D. 4 candidates are contesting election. So who is declared to be the winner of the election here? Sure. Is A the winner? But nobody is getting the majority. What is the majority here? More than 50. So anyone who gets 51 votes is the one who is getting the majority. But nobody is getting the majority. But still, is it possible to declare someone as a winner? Is there a winner in this case? There will be a winner in this case only if you follow the first past the post system. If you follow system of majority, then there is no winner. So if you keep majority as a benchmark to declare someone to be the winner, it becomes so complex because nobody may get the majority. Then the election result may not give you a winner. To make it a very simplest form of election, both in the election to the Lok Sabha and also to the Legislative Assembly election. So what is the principle that we follow? We follow what is called as first past the post system. And first past the post system said it does not matter how many votes you get. All that matters for someone to be winner is that one has to get more number of votes than all the other candidates contested the election. Therefore, who gets a more number of votes in this particular case? A has not got the majority, but still does A has got more number of votes than the other candidates. Therefore, who is automatically the winner of the election? A is the winner of the election. Such a system of election is what is called as the first past the post system. And where do we follow such a system? We follow this system in the Lok Sabha elections as well as in the Legislative Assembly elections. In every constituency, how many constituencies are there in the Lok Sabha elections? 543. In every 543 constituencies, in each and every single 543 constituencies, who will be declared to be the winner? Anyone has got more number of votes than the other candidates. Whether he gets majority or not, that does not matter. He has to get more number of votes than all the other candidates contested in that particular constituency. Then he or she is declared to be the winner of the election. That's basically what is called as the first past the post system. Is it clear to all of you? Now, what is the advantage of this first past the post system? Is the simplest form of election. Is it very clear that in every case there will be a winner? Unless and until there is an equality of votes. Even in equality of votes also, do you know what is the rule that is followed by the election commission? They'll follow a lot system. They'll draw a lot between the candidates who are having equal votes. So anyways, there will be one winner. Is it clear to all of you? So this is the simplest form of election. But can anyone tell me what is the drawback of this system? Is there a drawback of the system in the first past the post system? Say for example, I'll tell you the election results of the Tamil Nadu Assembly election for you to understand it clearly. Now, recently, in I think 10-15 days back or a month back, there was a new government in Tamil Nadu. And do you know that what is the vote share that has been got by the new government? Approximately around 35%. Of all the votes cast, what is the vote share? 35% they have supported that particular party and they have formed the government. That means of all the votes polled, how many people voted against that particular government? 65%. So 65% people did not like that. But however, 35% people favored, but still who formed the government? It is that particular 35% vote. That means here there is no need for any party to get majority because wherever they won by a slight margin. So that's the biggest disadvantage of what is called as a first past the post system. Similarly, at the national level, if I want to give the example, not this election, let me go to the 17th Lok Sabha elections. The 17th Lok Sabha elections, if you see, because in the 18th Lok Sabha election, BJP is a coalition government presently, but in the 17th Lok Sabha elections, That is when they won the elections in 2019, they had enormous majority. Do you know how many seats they won independently? No. It's more than 300. I think 303 seats is what they have got on their own. And then their coalition partners had. So overall, they had around 340 seats or something, if not the exact number. But let us assume only the Bharatiya Janata Party, BJP, they got 303 seats out of 543, which means roughly at least 60% of the seats. I'm putting it roughly, approximately 60% of the seats. But you know what is the vote share they've got? The vote share that they got is roughly 33%. Now, 33% of the votes has translated into how much seats in the assembly, in the legislature? 60% of the seats. It is because of the principle of what? First past the post system. Because wherever a candidate wins, it is not necessary that the candidate have to have the majority. All that the candidate has to do is what? All that the candidate has to get more number of votes than the other candidates. Let me give another simple example. Suppose let us assume the same, there is another, this is one constituency, let us assume this is another constituency. Again 100 votes, 100 voters are there. But out of those 100 voters, let us assume 10 or 15 candidates are contesting. How many candidates are contesting election? 15 candidates are contesting election. And there is only one person who has got 10 votes. So out of 100 votes, one candidate has got how many votes? 10 votes, but that is the highest of any candidate. Then still who is the winner? The person who has got 10 votes is the winner. So that is the example of what is called as a first past the post system. That doesn't mean that majority people liking him. 90% of the people does not vote to him. But how many people have voted to him? Only 10%, but that is the highest number of people or voter has voted to a single person. So automatically he is declared to be the winner of the election. So this system of election is basically what is called as the first past the post system. Is it clear to all of you? That means basically the criteria is what? Any person who's got the maximum number of votes in relation to the other candidates would be automatically declared to be the winner of the election. But the biggest disadvantage of this, it may not be exactly representative of the people's will. As I gave in Tamil Nadu, 65% of the people did not like it, but still they are able to form the government. At the national level, only 33 to 34% of the people voted for BJP in 2019, but still they are able to form the government because that alone individually is more than all the other parties. So therefore, they are able to form the government. Is it clear to all of you? So this is basically what is called as the first past the post system. But there's an alternative model. So some of the countries do follow an alternative model. But we do not follow this model, proportional representation, at least when it comes to what is called as election to Lok Sabha and election to the legislative assemblies. Because in our country, proportional representation would be a very complex thing. Why are we following the first past the post system? Despite the fact that it is not truly representative, because it's the simplest model. But there's an alternative model, which is also called as proportional representation. Please write down what is proportional representation. I'm giving the idea of a basic model of proportional representation, although there are different types under proportional representation, but the basic model is, write down, in proportional representation, the representation of, in proportional representation, the representation of the elected members, the representation of the elected members in the legislature, the representation of the elected members in the legislature is proportionate to their vote share. 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 For example, I told in case of the national level, Bharatiya Janata Party, BJP has got how much vote share? 33 to 35% approximately. But how much is the representation in the Lok Sabha? Approximately 60%. Is it proportionate in nature? It is not proportionate in nature. Suppose let us follow a system of what is called as proportionate representation. Now, what happens in proportionate representation is that there will not be elections to every constituencies in proportionate representation. All right. So what will happen is, suppose let us assume that India has one single constituency. Let us assume the entire country is one constituency. and as many parties they wanted to contest election. The candidates will not contest election. Who will contest election? Parties will contest election. Suppose let us assume there are 4 parties contesting election in India: Indian National Congress, BJP, and say let us assume couple of other parties. Let us assume, you can assume whatever you want. So there are 4 parties. So let us take the example of 4 parties. For that reason, we'll put again the same thing: A, B, C, D. So A is getting 40%, B is getting 30%, C is getting 20%, and D is getting 10%. For easy calculation, let us assume that our Lok Sabha is having 500 seats, just for easy purpose. Okay, it's not the case, just an example, hypothetical example, 500 seats. So in proportional representation, it is not that the candidates are contesting election, but the parties are contesting election. Who are contesting election? The parties are contesting the election. Is that clear? Now people are voting to the party, not to the candidates. So overall, party A has got 40% of the votes polled. Party B has got 30% of the votes polled. Party C has got 20% of the votes polled, and Party D has got 10% of the votes polled. Therefore, Party A has the right to nominate 200 members to the Lok Sabha. Because what is the vote share that they have got? 40%. Therefore, it is for the party to decide to nominate 200 members. The party itself will decide. But how many seats or how many members they can nominate? They can nominate only 200, because how much is the vote share that they've got? 40%. And the party B will have the right to nominate 150 members, because what is the vote share that they've got? 30%. And party C has the right to nominate 100 members, because what is the vote share that they've got? 120%. And the party D will have the right to nominate 50 members, because what is the vote share that they've got? 10%. Is it not proportionately representing the vote share in the legislature? So this system is what is called as proportionate representation. Although there are different models, different versions of proportionate representation, but the idea of proportionate representation is this. This is the basic idea of proportionate representation. But however, in India, at least when it comes to election to the Lok Sabha and Legislative Assembly, we are not following the system of what? The proportionate representation, but rather we are following the system of first past the post system. Is that clear to all of you? But however, there are few elections where we do follow a modified version of proportionate representation. But there's not very significant elections as the Lok Sabha elections and the State Assembly elections. So we'll deal with all those things. But however, the primary difference between first past the post system and the proportionate representation is what? Is that in case of the first past the post system, there is no need to get the majority. So anyone who's got the more number of votes will automatically be declared to be the winner. But whereas in proportionate representation, the representation in the legislative body will be proportionate to the vote share of a particular party. Is it clear to all of you? So this is the fundamental difference between what is called as first past the post system and proportionate representation. Yes, I told you there are different models of it. Yes, it is more party centric, because people are voting to whom? People are voting to the parties. But do you think that in India, in the first past the post system, also there is more individual centric? Today in Tamil Nadu, the entire state has voted for only one person. It is not an individual. No other individual are even known. There are many ministers who are even known to people. So even today, despite the fact that we follow the system of what is called as the first past the post system, how many of you think that most of the MPs won in the election just because of the Prime Minister himself? It may not be because of the individual themselves. If they're so popular as an individual, some of them might have within a party. But even in the first past the post system, also what dominates? It's a party that dominates. Alright, the party structure and the party that dominates. But yes, I do agree with the fact that in the proportional representation is more, relatively, the importance of the party is more. Which one? No, independent candidates can have. Independently, he gets a vote share. He may win. See, in any country, they do not completely follow what is called as proportionate representation, and they follow what is called as the first past the post system. In most of the countries, even in the advanced countries, they follow a combination of what is called as first past the post system and proportionate representation. That means in certain, because to give representation to what is called as independent candidates, they may allocate few constituencies where there can be independent candidates. In the rest of the area, they will follow what is called as the proportionate representation. Is that clear to all of you? But this is a basic idea. Even today, in most of the countries, they do not follow what is called as a proportionate representation. In most of the countries, they follow what is called as the first past the post system, because it is very simple. Come to the next thing, that is secret ballot. Secret ballot. So what do you mean by secret ballot? Voting in secrecy. Voting happens in what is called as secrecy. How many of you voted to the Lok Sabha elections or legislative assembly elections? You can just close and think in your eyes how the voting has happened. That has it been revealed to others when you voted? Nobody knows to whom you have voted. It is up to you whether to reveal or not to reveal, but nobody can force you to reveal. So such a type of election is what is called as the secret ballot. So just write down a line. In secret ballot system, in secret ballot system, the voting is cast. The voting is cast in secret. The voting is cast in secret. Example, can you give me an example of where it happens through secret ballot? Election to Lok Sabha, election to legislative assemblies, they are all based on the principle of what is called as secret ballot system. Election to the Lok Sabha, election to the state legislative assembly, they are all based on secret ballot system. Against a secret ballot, there is also a system of what is called as open ballot. What do you mean by an open ballot system? Say, for example, if I ask that this weekend there is a test in whatever you learned till this point of time, that is the original idea. But however, I am saying that how many of you wanted to have that particular test? If majority of the people in this class doesn't want to have the test, we'll cancel the test. I'm just asking that particular question and asking you to raise your hand in the class. So the first question is, how many of you are supporting this idea that you want to have a test? Please raise your hand. Then, okay, how many of you does not want to have the test? Please raise your hand. So here you are opening, you are raising your hands in front of others. So will everybody will come to know whether you wanted to have the test or how many of you does not want to have the test. So such a type of voting is what is called as voting in open ballot. So open ballots basically means that the secrecy of voting is not maintained. So others will know what is your choice. Others will know what is your opinion on that. Is that clear to all of you? Such a type of voting is what is called as open ballot. So write down a line. In open ballot system, the open ballot system, the voting is not done in secret. The voting is not done in secret. The voting is not done in secret. So can you give me an example where it happens in open ballot? Yes. Most of the things in the parliament is only on open ballot, not just passing the bills. Most of the things, what happens in the parliament, everything is based on what is called as open ballot. Say, for example, passing an ordinary bill, passing a constitutional amendment bill, voting on various motions, electing the speaker, removing the speaker, electing the deputy speaker, removing the deputy speaker, whatever happens in the parliament or for that matter state legislature, mostly they are based on the principle of what? Mostly they are principle of open ballot system. Is it clear to all of you? So normally a bill will be presented and then the presiding officer, that is a speaker, will ask, how many of you are supporting this bill? Raise your hand. So people will say A and they'll raise their hand. How many of you are rejecting this particular bill? People will say no and they'll raise their hand. So this type of voting is what is called as open ballot system. All right. So most of the proposals, most of the things in the parliament or the state legislature, that happens by open ballot. Write down the next concept, ex officio. Write down ex officio means by virtue of one's office, by virtue of one's office, by virtue of one's office, or by virtue of one's status. Ex officio means by virtue of one's office or by virtue of one's status. ONES, it is not ONC, by virtue of one's office and or by virtue of one's status. For example, have you ever heard that the Vice President of India is the ex officio chairman of Rajya Sabha? Have you heard of this word? So write down example. The Vice President of India is the ex officio chairman of Rajya Sabha. For example, the Vice President of India is the ex officio chairman of Rajya Sabha. The Vice President of India is the ex officio chairman of Rajya Sabha. So here you try to understand nobody is elected as a chairman of Rajya Sabha. What happens as per the constitution? Somebody is elected as a vice president, and by virtue of that office, whoever is a vice president automatically becomes what? Automatically becomes a chairman of Rajya Sabha. So the vice president is becoming the chairman of Rajya Sabha in ex officio capacity. So ex officio means by virtue of one's office, automatically they may hold on to another office. So such a provision in the constitution is what is called as ex officio. So I'm just repeating it again. The vice president is the ex officio chairman of Rajya Sabha, which means nobody is elected as a chairman of Rajya Sabha. So what happens to that particular post? Anyone who is elected as a vice president, he is automatically becoming the chairman of Rajya Sabha. In which capacity? In ex officio capacity. Yes. That is not in the vice president election or in the president election. That is not the case because the constitution says that it is based on secret ballot in case of vice president. So I'm not sure what you have seen because it cannot violate what is given in the constitution because the vice president election is especially explicitly given it is based on secret ballot. There is an election when it has to the members of the Rajya Sabha. In the members of the Rajya Sabha, there is a system of what is called as open ballot. I do not know what you have seen. You can just go and verify it. Anyways, that is not what we are discussing right now. We are discussing about what is called as ex officio. So what do you mean by ex officio? Ex officio means that someone who has occupied a particular office, automatically they can hold on to another office by virtue of they occupying another office or by virtue of they getting elected to another office. That's basically what is called as ex officio. Is that clear to all of you? Okay, so please write down the next thing. There can be no speaker to Rajya Sabha. There can be only chairman to Rajya Sabha. There can be speaker only to Lok Sabha. What is your question now? No, whoever is the presiding officer in the Rajya Sabha, he or she is called as chairman of Rajya Sabha. Whoever is the presiding officer of Lok Sabha, he or she is called as a speaker of Lok Sabha. To the speaker, there can be a deputy speaker. To the chairman, there can be a deputy chairman. Yes, what is your question? You are asking, can there be an ex officio speaker in the Lok Sabha? There is no such provision in the constitution. It is only the vice president who will become an ex officio chairman of what is called as the Rajya Sabha. In the Lok Sabha, they all have to be elected. There can be no one which can become an ex officio speaker. That is not possible. Okay. So please write in the next thing, that is the veto powers. So just write down a line as to what is a veto power. But before that, have you ever heard of this veto powers? Not in the context of the Indian constitution, but in general. Can anyone tell me what is your understanding of veto powers? Your general understanding of veto powers. Then we will see as to in the context of Indian constitution in the future. But I just wanted to explain you what is a veto power. Very good. That means basically if everybody in the group vote in a particular way and one single individual does not agree to that, still he can do with the decision of the entire group. That is basically what is called as a veto power. And I'm sure that most of you might have heard about this in the context of the P5 countries in the United Nations. Because all the P5 members in the United Nations, they have got what is called as veto powers. Even a single country can veto a decision that is taken by a larger group. That's basically what is called as a veto power. So write down as to what is a veto power. Veto power basically means power of an individual, power of an individual, power of an individual. Here the individual means it can be an individual person or an individual country, whatever it is, power of an individual to reject, to reject, to reject the decision taken by a larger group. Power of the individual to reject the decision taken by the larger group. To reject the decision that is taken by the larger group. So how it is relevant in the Indian Constitution, you will understand. So this write down. In the Indian Constitution, it is understood. It is understood. The President of India, in the Indian Constitution, it is understood. The President of India can exercise certain veto powers. Certain veto powers whenever the bill is presented for his assent. Certain veto powers whenever a bill is presented for his assent. Whenever a bill is presented for his assent, although these veto powers can be exercised by the president, although these veto powers can be exercised by the president only under special circumstances. Although these veto powers can be exercised by the president only under special circumstances. Only under certain special circumstances. That means the basic understanding you should have is that this veto power is not a normal routine power of the president. It's not routinely that he can exercise his veto power. So whenever the bill is presented, after it is passed by the parliament, it is not the power of the president to always say that no, I will not give the assent to the bill. Because anyways, we have understood that the president is what type of executive in our country? Only a normal executive, and he has to act on the aid and advice of whom? Aid and advice of the Prime Minister and the Council of Ministers. Therefore, normally once a minister's advice, he has to give the assent. But under certain exceptional, under certain special circumstances, he may also say no. That we'll try to understand as we'll proceed. But what does it mean by veto power? Veto power basically means that even after a larger group has accepted it, a single individual can reject that proposal. That's basically what is called as veto powers. So under the constitution, this power can be exercised by the president. But the most important thing that you have to keep in your mind is the word veto power is nowhere mentioned in the constitution. So the word veto is explicitly nowhere mentioned in the constitution. How many of you know about that? So because most of you might heard for a long period of time that the president exercises veto powers, but however this word is nowhere mentioned explicitly in the constitution. It is only implicit that he can exercise these powers. So please write down one more line. So however the word veto is nowhere mentioned in the constitution. So sometimes UPSC asks this also whether it is mentioned in the constitution or not. So however the word veto is nowhere mentioned in the constitution. Is that clear? So it's only an implicit understanding. It is not explicitly given. Implicitly that the president can exercise what? The veto powers, but that too under what? That too under certain circumstances, not always. Okay, so write down the next thing, that is ordinance. So how many of you heard about this word ordinance? Yes, can anyone tell me what in your understanding is an ordinance? So basically, what is an ordinance? You are understanding the circumstance under which an ordinance can be issued. But my question is, what is an ordinance? It's a law. So if you say ordinance is a law, that is correct. But when you say ordinance is a law, then how is it different from a law made by the parliament? Because the parliament can also make a law, and ordinance is also a law. That I agree. But are these laws same? The law made by the parliament. Okay. So first of all, tell me who can issue an ordinance in our country? the president at the union level, and the governor can also issue ordinance at the state level. So both are law, but my question is how this law in the form of an ordinance, which is issued either by the president or the governor, how is it different from the law that is made by the parliament or the state legislature? All right, so that's a procedural difference, but in effect, how it is different? Yes, very good. So that is the most important thing. All the laws which is made by the parliament and the state legislature are permanent laws, but an ordinance is a temporary law. That is what is very important. Just write down a line. An ordinance is not a permanent law, because who is supposed to make law under the constitution? The legislature is supposed to make law. Just write down the definition, then I'll explain it. Ordinance is a temporary law. Ordinance is a temporary law made by the executives. Ordinance is a temporary law made by the executives. So ordinance is basically what? Ordinance is a temporary law made by the executives. Write down further. The president under Article 123. The president under Article 123. The president under Article 123 and the governors under Article 213 can issue ordinance. Can issue ordinance. The president under Article 123 and the governors under Article 213 can issue ordinance at the center and the state level respectively. At the center and the state levels respectively. In both the cases, the ordinance will automatically lapse. In both the cases, the ordinance will automatically lapse. What do you mean by lapse? That means it becomes invalid after that. In both the cases, the ordinance will automatically lapse if they are not approved. If they are not approved by the respective legislature. If they are not approved by the respective legislature within a period of 6 weeks. If they are not approved by the respective legislature, if they are not approved within a period of 6 weeks, once they come into session. Once they come into session. Once they come into session. All right, so basically, please listen to me as to basically what is an ordinance. An ordinance is a law, no doubt. A law made by the parliament is also law. A law made by the state legislature is also law. An ordinance issued by the president is also law. An ordinance issued by the governor is also law. But what basically is the difference between the law which is brought in by legislative body and the law issued by the president or the governor in the form of an ordinance? One is a permanent law, another is a temporary law. In fact, we have understood the concept of separation of powers. What is the concept of separation of powers that we learned in the last class? The concept of separation of powers is that different organs in the state will have different powers. And who is supposed to make laws under the concept of separation of powers? Legislature. Normally, who is supposed to make laws? The legislature. But the Constant Assembly is of the opinion that yes, it is the legislature who is supposed to make laws, but the legislature can make laws only when they meet together. It might be possible under some exceptional or extraordinary circumstances, they may not be able to meet for some time. Say, for example, during COVID, the parliament was not able to meet almost for a period of 6 months. The same thing may arise, suppose if there is a war in our country. because it is very risky for the members of the parliament to come and meet. For some reason, they may not be able to meet. These are some exceptional circumstances. And if they are not able to meet, what they cannot do? They cannot enact any law if there is a need. But if they're not able to meet and if they're not able to enact a law, that should not be the ground that the governance of our country will get affected if there's a need for an urgent law. Therefore, in exceptional cases, even if the parliament is not able to meet, who can bring in a law temporarily? The president can issue an ordinance as a temporary law. And similarly, at the state level, if the state legislature is not able to meet for some reason, some exceptional reason, who can bring in the law, temporary law? The governor can bring in the temporary law, but these are only temporary law. They're not like the laws made by the parliament and the state legislature. And anyways, a temporary law or the ordinance has to be placed for the approval of whom? For the approval of the respective legislature. And within what time they have to be approved? They have to be approved within a period of 6 weeks once they come into session. So whenever they come into session, that means whenever they sit in the parliament, from that day, within how many days it has to be approved? It has to be approved within a period of 6 weeks. Otherwise, the ordinance will automatically lapse as if it is no longer a law. Is that clear to all of you? Therefore, the ultimate authority, even to approve the ordinance, is whom? It is the respective legislature. But till the time they come into session, temporarily, that ordinance can continue to be there. So once a parliament makes a law, it's a permanent law, but not the ordinance. Ordinance is not a permanent law because ordinance has to be approved by whom? It has to be approved by the respective legislature. But the ordinance will help us to meet out the temporary period where the legislature is not in session. So it is not going to affect the administration of our country because there is a need for an urgent law, but the legislature is not in session. Is that clear? That is the idea of this ordinance. I'm just giving a basic idea. So what is that you have written with regard to the ordinance? What is the last point you have written? In a period of 6 weeks. Okay, all right. So that gives a basic idea with regard to what is an ordinance. All that's a very big topic, but I'm just trying to give the basic idea with regard to ordinance. Right on the next thing, that is defection. So here, defection in the sense we are concerned in polity, which is related to what is called as a political defection. So can anyone tell me what is your understanding of political defection? What do you mean by defection? Hmm. After electing from one party, he can move to another party. He can move under defection. So the very idea of bringing in this defection law. So today we have what is called as an anti-defection law under the constitution. The very idea of this anti-defection law today in the constitution is to prevent political defection. So probably you are saying what is defection. So defection means that someone who's got elected from one party, after getting elected from one party, he joins another party. Then in that particular case, it becomes what is called as political defection. But tell me, a person who belongs to one party, can he join another party? Now, what do you mean by two-third majority? I'll tell you an example. Say, for example, today, let us assume a regional party. I'm not taking the party name. A regional party. That regional party has one party. That regional party has got 1 crore members. How many members are there in that party? 1 crore members who have registered themselves in that particular party. Now, when I say political party members, it doesn't mean that they're elected MPs or MLAs from that particular party. Not only they are the members of the party. A party should have its own cadres. They're all members of that particular party only. They're all taken the membership of that particular party. That's okay. So, someone who is a member of a political party X, can he join a political party Y? So, the anti defection law is not talking about an ordinary member of a political party. The anti defection law or the defection will come into picture only for a member of a legislature party, not a member of a political party. So, there is a clear distinction between these two words. That is, a member of a political party and a member of what is called as a legislature party. So can anyone tell me what distinction does it make when I say a member of a political party and a member of a legislature party? So in this case, there is no application of anti-defection law. So where the anti-defection law applies is only in this case. So defection basically means that a person is changing his party loyalties. That is in general term what is called as defection. That means under the constitution, what is prevented is only someone who has become a member of a legislature party, then he joins another party. That is only prohibited. Not someone who is a member of a political party, he joins another party. Suppose someone who is a member of political party X, can he join the political party Y if he wishes? If he feels no longer his ideology aligns with the original political party, therefore he can go and join another party. That is not defection. But when I say member of a legislature party, so when I say a member of a legislature party, say for example, recently I came across for the Bharatiya Janata Party, there are 9 million subscribers probably. Suppose not all the 9 million subscribers have taken the membership, but let us assume that there are 2 crores, 3 crores who have taken the membership of the BJP party, but they are all members of the political party. They are not member of the legislature party. Do you know in the 18th Lok Sabha, how many members of the legislature party is there? When I say member of the legislature party who has got ticket from that particular party and who has also won elections from that particular party, they are all called as a member of the legislature party. So how many MPs are there from the BJP party in the 18th Lok Sabha? 240 MPs. Though these 240 MPs are members of what is called as legislature party. That means they are representing that party in the legislature. So the anti-defection law applies to whom? The anti-defection law applies only to the member of the legislature party. It does not apply to each and every member of a political party. Therefore, as an example that you have taken, these 240 MPs from the Bharatiya Janata Party, so they have become MPs, the members of parliament in the Lok Sabha, from which ticket they have contested election? From the Bharatiya Janata Party. So therefore, they cannot change the party. If they get elected from one party ticket and then they join another party, then that becomes what is called as political defection. And what is a punishment for a political defection presently under the constitution? The punishment for political defection is what? It is not debarment, that is what is called as disqualification. So what is the punishment for defection presently? The punishment is disqualification under what is called as anti-defection law. They can be disqualified, although there are certain exceptions to that. We are not concerned about the exception at the moment. So the punishment is presently what is called as disqualification. But what I wanted to make it very clear is, today the defection or the anti-defection law will apply only to whom? Defection has to be seen, or the anti-defection law will apply only for a member of a legislature party, not to a member of a political party. Is that distinction clear to all of you? Okay, so please write down as to what is defection first. Defection basically means a person changing his political loyalties. Defection basically means a person changing his or her political loyalty. Defection basically means a person changing his or her political loyalty. Under the Constitution of India, to prevent political defections, under the Constitution of India, to prevent political defection, there is an anti-defection law. There is an anti-defection law which applies only to a member of a legislature party. Which applies only to a member of a legislature party. Which applies only to a member of a legislature party. Under the anti-defection law, if a member of a legislature party, under the anti-defection law, if a member of a political party, if the member of a legislature party defects, If the member of the legislature party defects, then he or she is liable. Then he or she is liable to be disqualified. If a member of a legislature party defects, then he or she is liable to be disqualified. He or she is liable to be disqualified to be part of that particular legislature. He or she is liable to be disqualified to be a part of that particular legislature. He or she is liable to be disqualified to be a part of that particular legislature. For example, if someone is a member of parliament from Lok Sabha, he got elected from one party but he joins another party, he or she is liable to be disqualified from where? To be a member of Lok Sabha. Suppose if somebody is a member of Rajya Sabha, he got elected from one party, joins another party, then he or she is liable to be disqualified as a member of parliament from which house? From the Rajya Sabha. Is it clear to all of you? So this is basically what is called as an anti-defection law. Yes, that does not disqualify him from contesting election. He is disqualified for time being. He is disqualified for time being. And remember, under the laws in our country, whenever there is a vacancy, suppose what is the term of the Lok Sabha? 5 years. Suppose this happens after 2 years. After 2 years, a member of one party joins another party in the Lok Sabha. Therefore, he is disqualified. Therefore, the next 3 years cannot lie vacant. Somebody has to be elected from that particular constituency. Therefore, for time being is disqualified. But again, when the by-election comes, within 6 months, the election commission has to conduct a by-election there. So in the by-election, he can again contest election from the new party which he has joined or as an independent candidate. The law does not prohibit that. But he cannot continue to be a member of the parliament by changing his party from one party to another party. That is not possible. So immediately he shall be disqualified. And then after that, in the by-election, if again people vote and elect him, he can again become member of parliament and he can continue to be the member of parliament for the remainder of the term. That's okay. But without disqualifying, he cannot continue to be a member of parliament after the defection. That is what you'll have to understand when it comes to the anti-defection law. So yes, the classic example today is Mr. Raghav Chadha, who has joined from Aam Aadmi Party from the Bharatiya Janata Party. But however, there are few exceptions under the anti-defection law. So in this case, I'm not sure whether the exceptions will apply or not. But there are a lot of loopholes with regard to the anti-defection law, which you'll understand subsequently when I deal with the anti-defection law, which itself will take me around 45 minutes to complete the entire provisions related to the anti-defection law in the Constitution. But the point right now is not to discuss all those things. The point just now is to make you understand as to what is defection. Is it clear to all of you? No, they don't use the word re-election. Re-election is when they cancel the election in total and they elect newly. So, for example, what happened in West Bengal today? There is one particular constituency, if I remember. Anybody from the state of West Bengal? Fault, I think, one particular constituency where they cancelled the election completely, although it has held. So, in that particular case, it becomes what is called as re-election. But by-election is always for a casual vacancy. Suppose somebody already got elected and it become vacant because a member died or for any of the other reason. So in that particular case, it is called as by-election. So these two are not one and the same. Is it clear? Okay, so please write down the next thing, that is bills. So write down the next thing, that is bills. So bills is in plural, but in singular it is bill. So can anyone tell me what is a bill? Okay, so please write down a bill is a legislative proposal. A bill is a legislative proposal. Once this proposal is accepted by both the houses of the parliament or the respective legislature, because the bills are not only introduced in the parliament, it can also be introduced where? In the state legislature as well. So basically, bill is what? Bill is a legislative proposal, and once accepted by the legislature, right on, once accepted by the legislature, and given assent, once accepted by the legislature and given assent by the president or the governor, the bill becomes an act. The bill becomes an act. Only when it becomes an act, right? Only when it becomes an act. Only it becomes an act, it can be legally enforced. Only when it becomes an act, it can be legally enforced. A bill cannot be legally enforced. Only when it becomes an act, it can be legally enforced. A bill cannot be enforced. A bill cannot be enforced. So please listen to me. So therefore, bill is merely a proposal, and that proposal in itself cannot be implemented as a law. So when a bill can be enforced, the bill has to be accepted by the legislature, and after it is accepted by the legislature, who has to give the assent to that particular bill? The president. Suppose if the bill is passed by the parliament, the president has to give the assent. Suppose if the bill is passed by any of the state legislature, then who has to give the assent? The governor has to give the assent. Only when they give the assent, then the bill takes a form of what is called as an act. And when it becomes an act, then we call that as a law. Then that can be enforced in a court of law. Otherwise, a bill in itself cannot be enforced in a court of law. So these are all merely legislative proposals. And that bill has to become an act only when the president gives assent or the governor gives assent, then only it can be enforced in a court of law. Is that clear to all of you? Sorry, then only it becomes a law, it can be enforced. Say, for example, Right to Information Act. Have you heard of this? But this Right to Information Act was initially introduced in the parliament as a Right to Information Bill. So the bill cannot be implemented. The bill does not give us the right to seek information. But what gives us the right to seek information from the government? The act gives us information. So the bill goes through a lot of process in the parliament, and then after all those things, who has to give the assent to this? The president has to give the assent, which has happened in case of the Right to Information Act. Is that clear to all of you? But however, the point here is there's a lot of process we'll understand in the parliament chapter as to what process it has to undergo, what the president can do, and all those things. But right now, you should just understand as to what is a bill. You should not have any confusion when I use the word what is a bill. Now, further write down, there are different types of bills under the constitution. There are different types of bills under the constitution. So broadly, the bills are classified into the following types. Okay, so just write down only the classification for time being. So write down the first type of classification is a financial bill. A financial bill. Financial bill. Second type of classification, ordinary bill. Ordinary bill. Third type of classification is a constitutional amendment bill. Is a constitutional amendment bill. So broadly, if you see, the bills are only classified into these three types. What are the types? Financial bill, and then you have what is called as ordinary bill, and what is called as a constitutional amendment bill. So any financial bill cannot be an ordinary bill. Any ordinary bill cannot be a what is called as a constitutional amendment bill. These are all different mutually exclusive categories of bills. But within the financial bill, there are different types of bills. So write down further, only within the financial bills, it can be further classified. Only within the financial bill, it can be further classified into three types. There are three types of financial bills. It can fall under any of these categories. So for example, the three categories of bills within financial bill, one, first, money bill. Money bill. So within the financial bills, it can be further classified. Money bill, finance bill 1, and finance bill 2. So finance bill 2. So basically all these bills are called as what? Financial bills. But Specifically, if you see, a finance bill may fall under a money bill, or certain finance bill may fall as a finance bill type 1, or certain finance bill may fall as what is called as finance bill type 2. Is that clear to all of you? But the broader classification is what? Either it is a financial bill, or either it is a ordinary bill, or either it is a constitutional amendment bill. So for time being, just know what are the different types of bills. But we'll try to understand all these things when I take up the parliament chapter. Is that clear to all of you? So this is what you should know with regard to the bills. So bills basically means what? They are legislative proposals. So depending upon the subject matter, they may be classified into all these things. All right. Come to the next thing, that is assent. Assent. Assent is a process of giving approval to the bills. Assent is a process of giving approval to the bills when it is presented to the president and the governors. Assent is a process of giving approval to the bills when it is presented to the president and the governors. Assent is a process of giving approval to the bills when it is presented to the governors, when it is presented to the president and the governors. Collegium, write down collegium next. Collegium basically means write down, collegium basically means a group of members. A group of members who has got the authority to decide on specific subject matter. Who has got the authority to decide on specific subject matter. In the Indian context, who has got the authority to decide on specific subject matters. In the Indian context, collegium basically refers to a group of senior judges. In the Indian context, collegium basically means a group of senior judges in the Supreme Court of India including the Chief Justice of India, who will decide with regard to the appointment of who will decide with regard to appointment of who will decide with regard to appointment of the judges of the Supreme Court, appointment of judges of the Supreme Court and High Courts, and also the transfer of judges of High Courts, and also the transfer of judges of the High Courts. So what is collegium in Indian context? Collegium in Indian context, normally what does it refer to? It refers to a group of judges in the Supreme Court, including whom? Including the Chief Justice of India. The collegium itself is headed by whom? It is headed by the Chief Justice of India. So basically what this collegium will decide? They will only decide the names of the other judges to be appointed as the judges of Supreme Court, and also the judges to be appointed to the High Courts, and also the transfer of judges from one High Court to another High Court. So all those things will be decided by the collegium. They are the highest authority to decide all those things. But however, this is very important. However, the word collegium is nowhere mentioned in the Constitution. However, the word collegium is nowhere mentioned in the Constitution. It is merely a judicial innovation. However, the word collegium is nowhere mentioned in the Constitution. It is merely a judicial innovation. It's merely a judicial innovation. It's merely a judicial innovation. That means the constitution itself is not directly giving this power to the collegium. So over a period of time, who has created this collegium? The Supreme Court of India, through its judgment, created this collegium, and they have taken this power to themselves. It is not explicitly given in the constitution. It has a long history as to how the judiciary itself has taken this. But however, for time being, what you should remember is that the word collegium is what? Nowhere mentioned in the Constitution of India. And also you should understand what is basically collegium means, in which context the word collegium is used. Write down the next thing, that is suo motu. Suo motu or suo motu. Suo motu or suo motu. So both means one and the same. Okay, suo motu or suo motu. Suo motu or suo motu means on its own. What does it mean? On its own or by itself. On its own or by itself. In other words, write down. In other words, certain authorities under the constitution, certain authorities under the constitution, under the Constitution of India and under the ordinary laws, certain authorities under the Constitution of India and also under the ordinary laws has the power to take up certain cases suo motu. Certain cases suo motu. Certain cases suo motu. So what do you mean by suo motu? On their own. Say for example, listen to it, it will be very clear. So normally, do you think that the court takes up the case of suo motu? Suppose, say for example, your fundamental right is violated, let us assume. Do you think that the Chief Justice of India will know that your fundamental right is violated? He may not even be aware of it. Whose responsibility is to take that matter to the Supreme Court? It is an individual concern. You go and file a case, and then the court will be aware of it, and then the court may take the necessary steps. If you are right, then remedy may be given to you. This is with regard to an individual, but suppose let us assume there are some serious issues at the national level. It's not affecting one particular individual. It's a serious issue which is affecting the entire country. Many people are getting affected over a period of time. That is not in one single point in time. Over a period of time, it is getting affected, and which is repeatedly reported in the newspaper and all those things. Now, in such cases, if the Supreme Court of India want that nobody has to file a case, the Supreme Court of India can take up that case itself in suo motu capacity. That means on its own, the Supreme Court can take up those cases. So suo motu means what? On its own or by itself. One recent example is the Supreme Court of India in the recent past has taken up a case suo motu on its own, which is related to the road safety in our country. So recently it was highlighted there's a lot of road accidents in our country. Therefore, the Supreme Court of India has suo motu taken up this matter and issued notice to the government of India, because who is supposed to ensure the road safety in our country? It is for the government. So the government has to provide. So therefore, it has issued notice to the various state governments as well as the government of India in this particular regard. But nobody has brought this matter to the Supreme Court. Who has taken up the matter on its own? The Supreme Court of India. That's basically what is called a suo motu. Now, Supreme Court is not the only authority who can take up the matter suo motu. Has anyone heard of what is called as National Human Rights Commission? Have you heard of this National Human Rights Commission? So, National Human Rights Commission is one authority under the laws in India. It is not there in the Constitution, because the National Human Rights Commission is a statutory body. It is created by an ordinary law, not by the Constitution. So the National Human Rights Commission has the authority to take up cases suo motu whenever the human rights of the individuals are violated. Nobody has to go and file cases. They can also go and file, but who can also automatically take up the cases? The National Human Rights Commission can also automatically take up the cases. But you can ask me, how do the Commission know? How the Commission may know about the violation of human rights? Through the newspapers, media reports, and all those things. If they see some issue, serious issue, which is highlighted in the newspaper or in the media, they themselves automatically take up those cases. Is it clear to all of you? That's basically what is called as suo motu taking up of cases, suo motu or suo motu. That means on their own, they take up interest and they take up the investigation of those cases. That's basically what is called as suo motu. Right, and the next thing, public interest litigation. Right on a line, public interest litigation means litigations filed in public interest, and not for individual interest. Litigation filed in public interest and not for individual interest. In other words, in other words, public interest litigation dilutes the principle of locus standi. In other words, public interest litigation dilutes the principle of locus standi. LOCUS Locus standi. It dilutes the principle of locus standi. So you should also understand as to what is this locus standi. Right on. Locus standi means what is your interest? Or in which way, or locus standi means what is your interest, or by which way an individual is affected because of a case. What is your interest, or by which way an individual is affected because of a case. I'll write down one more line, then it will be very clear to you. Traditionally, the judiciary has accepted cases. Only if they are convinced. Traditionally, the judiciary has accepted cases only if they are convinced an individual has a locus standi. Traditionally, the judiciary has accepted cases only if they are convinced an individual has locus standi. If an individual has locus standi in a particular case. Now just stop here and listen to me. So basically, what is locus standi? Locus standi means that whenever an individual goes to the court, so we may go to the court taking up some issues to the court. Therefore, initially, before accepting the case, what the judiciary will look, which principle the judiciary will look? The judiciary will see whether the principle of locus standi is satisfying. And when the judiciary will be convinced that the principle of locus standi is there, that means whether you are affected because of this case directly. That is, what is your standing in this particular case, or by which way you are affected in this particular case. If you are affected, you have the right to knock the doors of the judiciary. That is basically what is called as a principle of locus standi. Is it clear to all of you? Therefore, there is no problem that an affected individual can go to the court. If I am affected because of some state action, I have the locus standi to bring it to the notice of the court. This is basically what is called as a principle of locus standi. But however, what did we learn? We learned that the principle of public interest litigation has diluted the concept of what is called as locus standi. So traditionally, who can go to the court? Only a person who is affected will go to the court. But over a period of time, the judiciary realized that even, let us assume, a person is affected because of some state action or for other means, he may not be able to go to the court, because to go to the court, what else he needs? It's not only that he is affected because he is a victim in a particular matter, but apart from that, he needs certain other things to go to the court. What are the other things he needs to go to the court? First of all, he should have a legal knowledge. Second, he should have the resources to hire the lawyer, to file the petition and to follow it up. So many people are victim for many reasons in our country, though they have the right to go to the court, but practically they may not be able to go to the court for the reasons of what? They may not have the knowledge, they may not have, even if they have the knowledge, they may not have the resources, because fighting cases in the court is a very expensive thing. Therefore, over a period of time, the court have come to this particular conclusion. Not in all the cases, only the affected individual have to come to the court. So, on behalf of an affected individual, who can also file a petition? Somebody else in the society can also file a petition. Say, for example, local social activist is there. The local social activist is probably having the legal knowledge also. Probably he is able to mobilize resources also. Therefore, even if X is affected in the society, but X is not fighting the case, who can file the case on behalf of X in the society? The social activist can file it. But when the social activist file it, he is not having a direct interest. There's no locus standi, but he is filing in what interest? He is filing in the interest of the public. So such petitions would be considered what is called as a public interest litigation. Is that clear to all of you? So this has started happening in our country from late 1970s. But initially, the judiciary was restricting itself to what type of cases? So whenever somebody goes to the court, what is the first principle the judiciary will see? Whether there is a locus standi. So otherwise, they don't accept the case. But now, over a period of time, gradually, the judiciary start entertaining what is called as public interest litigation. So to put it in a very simple way, public interest litigations are litigations filed by individuals who themselves are not directly affected, but on whose interest they are filing the case? In public interest, with bona fide intention, with good intention, they are filing these cases. Such petitions are called as public interest litigations. Although there is lot of issues with regard to public interest litigation also, the other side is also there. But for time being, you just try to understand what is public interest litigation. So come to the next thing, that is tribunals. Have you ever heard of this word tribunals? Write down. Tribunals are quasi-judicial bodies. Tribunals are quasi-judicial bodies which is similar to that of judiciary, in terms of their duties and responsibilities. It's not identical. It is similar to that of the judiciary in terms of their duties and responsibilities. Which is similar to that of the judiciary in terms of their duties and responsibilities. However, differ from judiciary. In terms of their jurisdiction. However, differ from judiciary in terms of the jurisdiction. However, differ from judiciary in terms of the jurisdiction, comma, independence, comma, service conditions, independence, comma, service conditions, etc. etc. So basically, how they are similar to that of judiciary tribunals, because they are also similar function. Say, for example, in a judiciary, why will go to a judiciary? Why will you go to a court? We'll go to a court to get some justice. So similarly, they can also go to some, in certain cases, you also go to the tribunals and to seek justice only. So therefore, their function is almost similar, but however, they are different in terms of what? Jurisdiction. Say, for example, who has got very broad jurisdiction between courts and tribunals? The courts have very broad jurisdiction, where a tribunal will have a very narrow jurisdiction. Say, for example, you can go to a green tribunal, national green tribunal, but it can take up cases only related to environmental disputes, nothing more than that. You can go to administrative tribunal, one related to the service disputes, nothing more than that. You can go to, say, let us assume the taxation tribunals, one related to what is called as taxation matters, nothing more than that. Therefore, whose tribunal is whose jurisdiction is very narrow? Tribunal, first. Second, not only about the jurisdiction, about their independence also. So, for example, in the last class, I told how the higher judiciary is having independence. We have seen that the judiciary in our country is an independent judiciary. How they have the independence? Because removing them is extremely difficult. Who is authority to remove the judges of the higher judiciary? It is a precedent after a motion is passed in the parliament. But whereas in tribunals, the government can remove them. So who is having more independence? The judiciary. Similarly, their service conditions are very strong. The judiciary service condition is very strong related to that of the judges in the tribunal. But despite all those things, the nature of function is almost similar. That is why they are called as quasi-judicial bodies. They are not exactly equivalent to that of judiciary, but they are quasi-judicial in nature. Right on the next thing, that is constitutional bodies. So what is your understanding of constitutional bodies? Mentioned in the constitution. How many of you agree with this mentioned in the constitution? Is it okay that it can be called as a constitutional body? By your understanding and definition, the political party should also be a constitutional body. Is the political party a constitutional body? Because the word political party is mentioned in the constitution. So all the political parties in our country are constitutional bodies? They're definitely not. So mere mention in the constitution does not make it as a constitutional body. But rather that body is directly established by a specific rule in the constitution. Then it becomes what is called as a constitutional body. What is a constitutional body? An institution or a body is established by a specific rule in the constitution. Then only it becomes a constitutional body. So please write down. A constitutional body is something specifically established by a specific rule in the constitution. Is established by a specific rule in the constitution, or by, when I say specific rule, means it's by a specific article in the constitution. A constitutional body is something which is specifically established by a particular rule in the constitution. Therefore, what is the protection it is having when it is established by a specific article in the constitution? What is the protection it is having once it is established by a specific article? Which means if this body is to be abolished, you will have to make changes in the constitution. Unless until you amend and remove this body is continue to exist. And we know that amending the constitution is not an easy thing. So therefore, this body is protected by what? This body is protected by the constitution. So you can write some examples of constitutional bodies. So for example, Article 324 establishes the Election Commission. So which article establishes the Election Commission? 324 establishes the Election Commission of India. So for example, Article 148 establishes the CAG, the Comptroller and Auditor General of India. So for example, Article 280 establishes the Finance Commission of India. So for example, Article 315 establishes the Union Public Service Commission of India. So unless and until you make these changes in these articles or you remove these articles, these bodies protected by the Constitution of India. Is it clear to all of you? Although there are much more constitutional bodies, to name a few, these are all the examples of what is called as constitutional bodies. So constitutional bodies doesn't mean that they are merely mentioned in the Constitution. They're established by a specific article or a specific rule in the Constitution. Though the word political party is there, but the Constitution specific article does not establish any political party. There's a mere mention. It does not make a body a constitutional body. Say, for example, the word tribunals is mentioned in the Constitution, but a specific article does not directly establish a tribunal. Therefore, the tribunal does not exercise and enjoy a constitutional status. But a specific article, Article 324 says that there shall be an Election Commission of India. Article 148 says there shall be a Comptroller and Auditor General. The specific article establishes these things. Come to the next thing, that is statutory bodies. Right down. These are bodies. These are bodies established by a specific statute. These are bodies established by a specific statute. Statute basically means ordinary law. So these are bodies established by a specific statute or an ordinary law enacted by parliament or state legislature. enacted by parliament or state legislature. These are bodies established by a specific statute or an ordinary law enacted by parliament or state legislature. Therefore, these bodies are created not by the constitution. They are not established by the constitution, but by what? But by ordinary law. These bodies are also protected, but they are protected not by the constitution of India. They are protected by what? They are protected by the ordinary law. So, relatively between a constitutional body and a statutory body, which is having better protection? Constitutional law. In both the cases, it can be changed, but changing the constitution is extremely difficult. But changing an ordinary law is relatively easier. So, therefore, in both the cases, this body is protected, but it is relatively protected better in case of what is called as a constitutional body. So, write down few examples for the statutory bodies. So, for example, I spoke about the Human Rights Commission. So, NHRC is a statutory body. National Commission for Women is a statutory body. Competition Commission of India. Have you heard of this? Have you heard of SEBI, Securities Exchange Board of India? Have you heard of RBI, Reserve Bank of India? These are all statutory bodies. RBI, SEBI, Competition Commission of India. There are thousands of statutory bodies. Just to name a few, these are all some of the statutory bodies. Is that clear? All right. So have a look into this particular question. So try to answer this question. Which of the following is true regarding the concept of judicial review? So what is the answer? It is a power of the judiciary to question both the actions of the legislature and the executive violative of the provisions of the constitution. So why the statement A and B is not correct? It is a power of the judiciary to look into the wisdom of the legislature. Why it is wrong? Executive is not there. Okay, now let me ask the question. It is a power of the judiciary to look into the wisdom of legislature and executive instead of just the legislature. See, wisdom means what? Basically, you are questioning their decisions. Wisdom is a collective decision that one body has taken. You cannot question whether it is right or wrong, questioning their wisdom, as long as it is violative of what? Violative of the constitution. Therefore, the judiciary always has one reference point. What is the reference point for the judiciary to question the action? Violation of the constitution. See, sometimes the judiciary, suppose let us assume a law is made enacted by the parliament, let us assume that law is not violative of the constitution, but the judges say that that is not a right decision. Can they strike down that particular law? That in the opinion of the judiciary it is not right. That they are questioning the wisdom, but questioning the wisdom is not the power of the judiciary. What is the power of the judiciary? The power of the judiciary is only to see, even if the law is bad, as long as it is not violative of the constitution, the law cannot be struck down by the judiciary. Is it clear to all of you? Because it has to be always in violation of the constitution. So that is basically what is called as judicial review. So therefore, the most appropriate answer is option B. All right. So please quickly go through the notes very quickly. So whatever you have seen in today's class, any questions, please ask me.